My name is Liz Moneymaker. I am an attorney in St. Petersburg, Florida. I mainly practice in Florida, though I'm also licensed in Georgia and Missouri. I practice virtually statewide. So if you know anyone in Florida looking for things like wills or trusts, powers of attorney, living wills, probate or trust administration, or Medicaid planning when it comes to long-term care for our citizens 65 years or older, then I would be happy to assist. And if it's something I can't help you with, I'm happy to try to find someone in my network that I know and trust that you can trust as well. So I started Lunch with Liz, like I said, about 3 years ago because I saw a lot of misinformation out there. Surprise, surprise, saw misinformation on social media, heard misinformation from people, including people that, you would expect to know more, like financial planners, CPAs. So I started this as a way to have a venue every month to have a casual conversation. I didn't want to do a podcast where I was just talking to a microphone. I wanted to do something where I put out a topic. If people were interested in the topic, they would come on. And so that's what we're doing here today. How it works is I talk for a little bit. Today I have some slides just because I think some people are more visual learners. So I'm going to throw some slides up there for you. Um, then we're going to open it up to questions. I'll have some scenarios because I think sometimes that helps as well. All right, so we're calling this Lunch with Liz Estate Planning 101. This is what we're going to talk about today. Generally speaking, when I am talking to a new estate planning client that comes in my door, I'm talking about using one or more of these documents in their estate plan. And we're going to talk about each one of these today. We have the durable power of attorney for finance. We have your medical directives, your last will and testament. Maybe we will talk about a revocable trust today. Maybe that's something I would use in planning for a client. And we're going to talk about some other ways as well that we can avoid probate. We'll talk a little bit about what probate is, just to make sure you understand that as well. I think I see some faces or names anyway that have come in to me for a consult. So you know that I divide estate planning into two categories. The first category we're going to talk about today is what happens if I'm alive, but I'm not able to make decisions for myself. I've been in a car accident. I've had a stroke. I have dementia. What documents can we have in place to make sure that someone you trust can make financial and medical decisions? That's the first part of Estate Planning 101 that we're going to talk about. The second part about estate planning is what happens to my stuff when I die? What happens to my clothes, my car, my jewelry, my bank accounts, my condo, my Picasso, all of those types of things. And that's the second part of what we're going to talk about today. When it comes to trusts are actually part of both of those categories. Trusts can be used to help plan for someone's incapacity, as well as what happens when they die. Next slide. All right, so first off, not having a plan is a plan. Because if you don't have something written down, there is a Florida statute out there that's going to make the decision for you. It's going to decide who makes your decisions if you're incapacitated. It's going to decide who gets your stuff when you die. And it may not be what you want. So that's what I tell my clients. Not having a plan is a plan. It just, might not be, and most likely is not what you actually want to do. This is why we think planning is critical. First of all, when we're talking about the incapacity planning, like if you're unable to make decisions for yourself, this is the only way that you can dictate who's making those decisions for you. It's the way to preserve as much of your assets as possible rather than those assets going to court fees and attorney's fees and potentially estate taxes, right? It's to make your wishes known to reduce conflict. For example, have clients that are adamant about what type of cremation they want and what they want to have done with their ashes, which is directly contradictory to the way that their families want the end of life um, results to be. So for them to have someone else in charge and have their wishes very clear will ensure that there's not as much conflict between the people that they've chosen and the people that the law would have put in charge of their remains had they not put this kind of stuff in writing. It also allows you to make your own choices when it comes to who's making the decisions for you, rather than, like I said from the last slide, whether it's someone that the law decides is going to make those decisions for you. And lastly, it allows you to protect beneficiaries, whether those are minors, for example, or they are of diminished capacity. Maybe they're special needs beneficiaries, maybe they're beneficiaries with other issues, which we'll talk about later. So if you don't do this type of planning, there's probably not going to be a good plan in place then for your beneficiaries, because it's just going to be some generic plan that the state of Florida puts in place for you. All right. So let's talk about that first category. Remember, I break it down into two categories. The first category is what happens if I can't make decisions for myself. And that's where we're at right now. So this is planning for incapacity. The single most important document that I believe that I provide to my clients is the durable power of attorney for finances. Even if you're married, you do not have authority to sign for your spouse, to make financial decisions for your spouse without being designated under this durable power of attorney. Give you an example. A 47-year-old friend, he was married, had a stroke, did not have this document in place. In order for his wife to be able to make financial decisions for him, including issues with refinancing their house so that they could make sure they have money to pay for his care, she had to go to court and get a guardianship. And I'm going to talk to you about that in a couple of slides. So had they had this document in place, she would have been able to handle things without having to spend the money to hire a lawyer and go to court and get a guardianship. What the power of attorney does is it lets someone stand in your shoes to do all those things that are listed there, as well as other things. And the reason we call it durable is because even if you become incapacitated, it stays in effect. And that's a critical aspect of the document, because that's really why you want the document, is in the event you can't make these decisions for yourself, you want your agent to be able to do it for you. I talked there about choosing your agent carefully. For the power of attorney, you definitely want someone that, do they pay their own bills? Can they balance their own checkbook? Are they responsible and organized? Generally speaking, I advise at least one backup, and if possible, a younger person. If I'm going to name someone that's close to my age, I might want to name a backup that's 10 to 20 years younger. We never know. We all are going to, we're all going to die. We don't know when that's going to be. But generally speaking and statistically speaking, you're safer putting someone at least 10 to 20 years younger there, so that you're not necessarily having to redo the document in the event that your primary person themselves dies or themselves becomes incapacitated. All right. Next document that we're talking about when it comes to incapacity planning is your medical directive. And these are called a multitude of words that you might hear: advanced directives, advanced medical directives, living wills, healthcare surrogates. Essentially, these documents serve three vital purposes. One is it sets out your living will. In other words, what type of life prolonging medical care do you want if you're unable to articulate your wishes? You're in a coma, you're to the point because of whatever issue that you have that you're unable to articulate. Do you want to have life prolonging care, or do you not want it to be kept alive artificially and simply let die in a, as much pain free as possible? This lets you dictate that ahead of time. It also lets you designate a healthcare surrogate. So that's the person that's going to carry out your living will wishes. That's the person that's going to advocate for you for a new hospital room or a new treatment plan or discussing with the doctor what type of rehab you're going to go to. So when you're thinking about a healthcare surrogate, I always tell my clients, yeah, it's important to pick someone that's going to follow your wishes, but it's also important to pick someone that is going to advocate for you when you can't advocate for yourself. So if it's someone that's very shy and is not going to assert themselves, they may or may not be the best choice when it comes to being your healthcare advocate. And just like the power of attorney, if you don't designate one, um, there will be a way for Florida to designate one for you. And it, again, may not be the person that you would have chosen had you been able to choose yourself. So without having these documents in place, if you then become incapacitated, you have a car accident, you have a stroke, you have some other event where you're either temporarily or permanently unable to take care of yourself, and you don't have these documents in place, that's when a guardianship has to be set up. And a guardianship in, 30 seconds or less is when you hire a lawyer, you go to court, and you ask the judge to take away the person's rights to make decisions for themselves. And you ask the judge to appoint someone else to make those decisions for the incapacitated person. It's an expensive process. And then once it gets set up, the judge requires yearly, if not more, reports on what's going on with the money and with the medical plan for the person. So it's not a it's not your first line choice of how to deal with incapacity. It's and if you have these other documents in place, not always, but most likely than not, then we can avoid having to have this expense and having this then permanent life altering imposition by the courts in someone's day-to-day affairs. So we've talked about what I say is the first category of estate planning. So incapacity planning, where we're talking about the powers of attorney and we're talking about your medical directives. That's the incapacity side of planning for your estate planning. Now we're going to switch gears and we are going to talk about what happens to our stuff when we die. And by stuff, I mean your house, your condo, your lake house, your cars, your savings and checking and money market and CDs and brokerage and all those types of accounts. What happens to all that stuff when we die? And before I can help a client get to where they want to be, I got to figure out what are their goals and what are their complexities. And this just kind of gives you an idea of when I first meet with a client to try to get an idea of where they're coming to me from. Did they marry and each of them had prior relationships with children? Did just one have a children from a prior relationship? Are we trying to disinherit children or siblings or parents? Do we have minor children? Or any of our beneficiaries, gamblers or drug addicts? Do we have beneficiaries with autism or Down syndrome or other types of special needs? Are we planning for pets? I've done a lot of bird planning. Apparently, birds live a very long time. I've planned for cats. I've planned for dogs to try to make sure that in the event something happens to us, we have a caretaker for the animal and funds then to caretake for the animal. Do you have assets in other states or other countries, including timeshares. Those things have to be dealt with. Are we worried about estate taxes? If so, that's going to have different types of tools that we want to use. And not listed up there, but another thing that I need to know because it really impacts planning is, do you have a non-US citizen beneficiary, whether it's a spouse or somebody else? So once I've gathered all of that information, and any good estate planning attorney is going to want to know all of this because that's the only way that you can craft a holistic plan that works. Then we start talking about, okay, what type of tools do we need or do we have that can accomplish getting where you want to be? So the first tool that we have is called a last will and testament. So essentially what a will is it's a document that states the person's wishes about what happens to their stuff when they die. Can also name caretakers for pets, guardians for minor children. If you are relying on a will to transfer your assets at death, it will require probate. Let's say that one more time. If you are relying on a will to transfer assets at death, it will require probate. But just because you have a will doesn't mean that you will need probate. And I'll circle back and explain that later. The key phraseology there is if you're relying on the will to transfer the assets at death, it will require probate. The next document is a revocable living trust. Think of a trust like a bucket. So if I draft a trust for you, think of that pieces of paper being the instructions that we put on the outside of the bucket. And then once we create that bucket for you, we put stuff in the bucket. We fund the bucket. And how do we do that? Well, we retitle assets. So instead of Liz's condo, now it's Liz's trust condo. Instead of Liz's bank account, it's now Liz's trust bank account. And it's a process to retitle those assets in this new bucket's name. What I see all the time, just saw it yesterday in my practice, well, people will get a trust, whether it's from a lawyer or they do it themselves, and they have a beautiful piece of paper. Like, it's actually a lot of pieces of paper, but nothing was ever done to actually put things in the trust, retitle assets into the trust. So now you've just created even more expense after you die, because now at death, we have to then put stuff in the bucket and then take it out of the bucket. So you've taken an expense and made it twice as expensive by creating this trust and not funding it while you were alive. Now, does everyone need a trust to avoid probate? No, no, no. What I look for, and what most of estate planners look for, hey, what's the least complicated, most cost-effective way to accomplish your goal? And you remember that slide a couple slides ago where we were talking about, blended families, minor children, special needs. Well, that's where all that comes into. So what's the least complicated, least expensive way to accomplish your goal? If you have a scenario that in order to accomplish your goal, for example, minor children, you don't want them to inherit $1 million, when they're 16, that's going to be a more complex plan where you most likely do need a trust. If you own property out of state, you most likely would need a trust in order to avoid probate. So it's not a one size fits all. It's funny, I'll get calls at the office, and Vicky fields most of these, but they'll say, well, what's the cost? I just have a simple estate. What's the cost? And the thing is, you get the lawyer answer, which is it depends, because people don't know what they don't know about what makes an estate plan complex or not, because we have to look through and see if you have any of these types of issues that we need to deal with. All right. So remember when I said before that if you're relying on a will to avoid probate, then you'll have to go, you'll, if you're relying on a will to transfer ownership, you will have to go through probate. And what probate is, again, 30 seconds or less. I do a whole lunch with Liz on probate. I think that was last month's topic. Um, Probate is where you have to hire a lawyer, open a court case with a judge, and typically it's 6 to 9 to 12 months, sometimes longer, transferring assets to the new owner at death. We have to name creditors, we have to serve creditors. It's a long, expensive process. So generally speaking, we try to avoid that. You don't avoid probate with a will. You may still need a will for other reasons, but you don't avoid probate with it. How you avoid probate is using some of these other techniques that are on the slide right now. One way, and this is typically what I see with married couples, is they have joint ownership in things. They jointly own their checking account. They jointly own their savings account. They jointly own the house. So that when one of them passes, there is not most of the time, but a lot of the times, there's no probate because that joint owner now is the legal owner of all of those assets. What I always want to caution people on is please don't run out and put your child or a non-spouse onto your bank accounts for the sole purpose of avoiding probate. You could run into a whole mix of issues there, including gifting, including if someone else is a joint owner on your account, if they get sued, that's their money that could be attached in any type of a lawsuit. If they filed bankruptcy, that's their asset. Additionally, it's legally their money, so they can go take everything out of the account and go put it in their own account. So you want to be very, very careful about just adding someone to a house or a bank account. Talking about the house, I had a couple cases recently where clients were like, yeah, I just added her on, just thought it would be easy, but now we're breaking up and I want to get her name off. I want to take her name off. Well, it doesn't work that way. Once you put the name on there, then that person has to agree then to take their name off. So you want to be very, very, very careful, and please talk to a lawyer and your CPA before you just putting anyone on a deed or jointly owning some type of bank account. The next way to avoid probate without necessarily having the will involved is pay on death designations. You might hear these referred to as PODs. So this is what you could do at your bank. Go to your bank and you fill out a form, and you can make the whoever you want to get those funds the beneficiary of those accounts. They're not a joint owner. They don't have any rights to the money, but upon your death, they have to present a claim form and the death certificate, and the monies then would be paid out to them. A very similar concept is the transfer on death designation. That's also called a TOD. So this is what you might do with brokerage accounts, mutual fund accounts, so that they transferred to a new owner at your death. They don't get paid out, so they don't necessarily have to cause a loss or a gain in the stock, but they get transferred to the new owner without probate. Beneficiary designations are a way to avoid probate on things like IRAs, 401ks, TSP accounts, 403bs, annuities, and life insurance policies. If your beneficiary says it goes to Sarah, then it's going to Sarah. Regardless, even if in your will you said everything goes to Tom, it's that beneficiary designation, that TOD designation, that POD designation that's going to dictate where those funds go. And then lastly, when it comes to real estate in Florida, we have a handy dandy tool called the Ladybird deed. The real term is enhanced life estate deed. But to make that easily explainable, it's just where we put a beneficiary on the deed. The person has no ownership interest in the home. They have no rights to the home until the death of the current owner of the home. You can take that person off, you can sell it, you can refinance it, you can do whatever you want to with the real estate, but upon your death, then it would go to the beneficiary you've named in the deed. And to kind of give you just a scenario about what that might look like, we'll go to the next slide. So in this scenario, let's say John owns a house. He has a checking and savings account, a brokerage account. He's got a retirement account as well, and a life insurance. And he has no spouse and no children, and none of those things that I had listed on that one slide that would make his life too complex, right? And he just says, "Hey, Liz, I want to try to avoid probate without creating a trust." So what we might do in this scenario is we would do a ladybird deed for the house, naming a beneficiary for that. We would make sure his checking and savings had pay on death designations. We would do a transfer on death designation for his brokerage account and make sure there's beneficiaries on his retirement and life insurance. We would still have the will for his tangible personal property, but other than that, he has avoided probate for all of these assets. We'll go to one more scenario and then we're going to open it up for questions. So get those, let me go back. Get those questions ready. All right, so this should actually say trust probate avoidance example because it's one with a trust. So in this scenario, Sarah owns property in Florida. She owns property in North Carolina, and she has all the same things that John did as well. But she wants to avoid probate. And let's say in this scenario, she doesn't have any kids, any family. So if she doesn't create a trust, if she uses a will to transfer her assets at death, she'll have a probate in Florida, and her executor will have to open up a probate in North Carolina because she owns that property there. So by creating a revocable living trust, remember that concept of like that bucket, we'd put the Florida home in the bucket. We would hire counsel in North Carolina to put that home in the bucket, put her other assets in the bucket, and thereby she avoids probate at death. If she had minor children, we could also use the revocable living trust to ensure that they got paid out at certain ages rather than getting a lump sum of money when they turned 18 or 21. If she had, let's say she had remarried, but she had children from her prior relationship, she can ensure that funds were safeguarded for her children after her death. So there's all sorts of ways that a revocable living trust could be used to address some of those complexities we talked about earlier, like special needs children, beneficiaries with gambling, alcohol or drug use issues, pets, charities, all types of things, avoiding estate taxes. I'm going to now, I'm going to stop sharing my screen. All right. And I'm going to look to see if we have any questions in the chat. Got a question. Do you have any getting started kits that can guide you? Yes, Kevin, that's a good question. I have an intake sheet that kind of walks you through the questions that help us know what type of tools we may want to use for your situation. We don't expect clients to have all the answers when they come see us, but this at least gets their juices flowing so they have an idea of what questions we're going to be asking. So that would be my starter kit, if you would. Laura asked, is it difficult to include a foreign property into the living revocable trust bucket? So if you mean foreign as an out of state, then no, it's not difficult. If you mean foreign as an out of country, then yes, it's not possible. Actually, if you have property in another country, we have to coordinate with that country's estate planning council to try to make sure that the two plans work together. Again, though, if you're talking about out of state property, yeah. If either my clients have counsel already where they have another property, or I connect them with someone through my estate planning attorney network, and we hire someone to do the deed and that other state. Usually, I don't know, depending on the state, anywhere between $300 and $600 to do a deed to trust from that other state. Next question. How much does a trust manager cost? I'm not sure what you mean by trust manager. So if you want to like give me another question or you want to come off mute and talk to me, I'm not familiar with a trust manager. Um, Next question. I have a revocable living trust and have accounts with TODs, PODs, and beneficiaries assigned. Do I need to put those in my trust? Likewise, I have accounts in my trust with TODs and beneficiaries assigned. Is that okay? Um, so if you have a trust, but you also have accounts with TODs, PODs, and beneficiaries, that could be fine. It just depends on what your intent is with the trust. Because think about it, if your trust says, I want everything to go to Liz, but all your beneficiaries is everything going to Susan, then the beneficiaries is what's going, the trust can only control what's in the trust. Um, when you say I have accounts in my trust with TOD and PODs, I would be surprised about that. If the trust owns them, the trust owns them. They wouldn't have TODs and PODs at that point. Um, but without knowing your exact situation, I can't tell you whether it's okay. If that's the plan that you and your attorney came up with, then I would discuss it and verify it with your counsel. And your your concept, what you have going on there, is not uncommon, to put it that way, to have some things in the trust and some things out. Um, if you have minor beneficiaries or you have special needs beneficiaries, you probably want to look at going for some other route than that, though. Um, but without knowing your specific situation, I can't say for sure whether that's going to work, right? Because it's like every person's goal, every person's concern, every person's situation is different. Um, Question. If I have already done my estate planning and I need to do changes, do I have to do it all over again or just change the items? For example, our healthcare surrogate. Um, Typically, you can update documents piecemeal. So if you needed a new healthcare surrogate, you could just get a new healthcare surrogate. If you needed a new power of attorney, you could just get that. Um, I would say I don't know how much that would be, what your attorney would charge you to redo it. Typically, um, they either have a set fee or they do it by their hourly rate, depending on what how they work their practice. Sometimes you buy a subscription plan where you get a free update every 5 years or something like that. So it just depends on how you and your counsel, had agreed on any changes that you would have made in the future. All right. All right. Yes. Okay. I got some clarification on if you establish a trust, someone has to manage it. How much does that cost? So while you're alive and competent, generally you're managing your own trust. You're your own trustee. So you're not charging yourself any money to manage it. Once you become incapacitated or you pass away, now your successor trustee is in charge. And you're going to love the answer, but it just depends. You set the rules in the trust about what their compensation is. Sometimes people say, well, if they're beneficiaries of the trust, serving also as trustees, they don't get compensation because they're already getting paid out of the trust. Some people do it as a percentage. Some people do it as a set hourly rate or cap the amount of money that the trustee gets. If you're hiring a corporate trustee, like a bank or Merrill Lynch or something like that, they're generally going to charge a percentage of the trust corpus, and there's generally going to be a minimum amount that they'll even consider being a trustee about. So that was the long-winded answer of it. It just depends on how much you've indicated in the trust that the successor trustee gets. Next question. If I have our main primary home in joint ownership with my spouse. If I die first, how can I name that my half is divided between my two children? You can't, because if it's a joint ownership with your spouse, when you pass, it becomes her property. Um, there could be other ways that you could do it. What I call that controlling from the grave. And if you're trying to control from the grave, you pretty much are always going to be looking at a trust-based estate plan to be able to dictate that. In your scenario there as well, you're going to need your spouse's agreement that that's what happens to the house after you pass. What if she lives another 20 years? What if she wants to sell it and go live somewhere else? What if she needs nursing home care? So these are the types of questions that I would be asking someone that came in for a consultation when they're asking to accomplish this. If this is their goal to make sure this house goes to their kids, we'd be asking all sorts of other questions about how it impacts homestead property rights, marital rights, that kind of stuff. I'm not really good at answering your questions today, am I? I'm giving you a lot of it depends answers. Uh, and if I've answered one of your questions and you want me to clarify that some more, or go a little deeper based on my answer, please let me know. I'm happy to do that. Let me circle back with Dr. Green too. So there is when you set up a revocable living trust, it's your social security number. Your taxes are no different. Nothing is really any different, except now you have sort of this pass-through transparent bucket that holds your assets. So nothing is different. The only time it becomes different is when you die. Now the bucket gets a lid put on it and it becomes irrevocable and it gets its own tax ID number. And that's when you're paying your successor trustee, if that's what your bucket instructions said. That's when you're filing trust tax returns, that kind of stuff. But while you're alive and you're managing your own trust, there's no additional fees for that.
I have a question.
Go ahead, Carol.
Hi. Thank you for all the good information. Once the trust is set up, you said that it has to be funded. Everything has to be moved into the trust. Once you set the trust up, who is responsible for making sure that everything gets then funded into the trust? Do you
Depends.
take care of that, or do I do that, or?
Yeah. Typically, in my practice, I have the client do that, and I can help. For example, we do the deed to the trust, so we can move your property, a Florida property, into the trust. We can have a three-way email or three-way conversation with your financial advisor about how to set those kinds of things up. But when it comes to go into your bank and moving those types of accounts, then that's just something we provide you instructions on what to do and how to do it, and we walk you through, as much hand holding as you need. But generally, it's you that actually has to go make the appointment and sit down with the banker.
Okay, but you assist in getting everything kind of outlined for me to do, so I'll know what to do and how to do it.
Correct.
Okay. All right. Thank you so much.
Yeah. Before I would even advise that you got a trust, we would have walked through your assets and talked about why you needed it and why it needed to be funded, and how to fund it. So
Okay.
it's a process from beginning to end.
Okay. All right. Thank you so much.
You're welcome.
Power of attorney has the power only when the person is alive, only, right?
Correct. Correct. Once the person dies, the power of attorney dies with them.
Okay. So,
Yep.
thanks.
You're welcome. We'll be doing a pretty detailed lunch with Liz later in the year about how to choose your power of attorney, how to choose your personal representative, which will also, if you're named as that agent or you're named as an executor or personal representative, it will be helpful for you to kind of know what you might be doing in the future, for sure. We'll have a professional fiduciary on, and that's someone that if you were in a position where you don't have family that you want, you don't have friends that you want to be making these decisions, there are professionals out there that will do it for a fee, of course. But they're trained, they're bonded, they're insured. We do to provide complimentary consultations for estate planning. We do that via Zoom, or we do that in person in our St. Petersburg office. We do not do it via telephone or email. But Zoom or in person, those are complimentary. Keep in mind, we had someone from New Jersey. If you're here from out of state, we only do estate planning in Florida. Estate planning is a very state specific, state statutes, state case law. So if you're from another state, you definitely want to hire counsel that is licensed in your state. And if you want help finding one, give us an email. We'll find someone in our network that would be able to help you. All right. Oh, hey, Tom. Question. How many hours on average is it to set up a durable POA, directive, and trust? Of course, it varies in complexity, but rough estimate. I couldn't even estimate, Tom, how many hours on average it is to set up. I don't charge by the hour. Anyway, I charge a flat fee once I have met with you and I understand your plan and understand what tools I need to use to get you where you want to be, then I provide you with a flat fee as to cost. I would tell you that if it's someone who's married for a trust-based plan, and we want to do a joint trust with the wills, the powers of attorney, the healthcare directives, the deed to trust, and all that, I'm going to typically flat fee that out between $3,500 and $4,500, depending on if you have minor children or some of those other complexities. That's generally the ballpark for a joint trust for me. All right, well, I think we're about to the top of the hour, so we'll call this one. Next month, we have a special Pride episode. We're going to take July off, and then in August, we'll be back with a guest speaker talking about estate planning for businesses. So business succession planning, what you need to set that up, how that then intertwines with your personal estate planning tools. Be a great episode. So if you are a business owner, you know a business owner, definitely tell them about August lunch with Liz. If I didn't get to your question, you have other questions, feel free to call us or email us. We're happy to set up a consultation to talk about it further. So thanks everyone for coming, and hopefully we'll see you in June for our Pride episode. If not, we'll take July off and see you in August for the business succession planning.